Welcome to this presentation regarding litigation pleadings. I'm going to share my desktop so you can see what I'm seeing, and we're going to go through several. What is a pleading? And some general concepts about the pleading. So I'm going to go to this PowerPoint presentation that you also have available to you in the learning module relating to litigation pleading. You can see here, there's a little picture. Obviously, there's the judge is here. He has his hand over the microphone. He does that so that whatever is being said is not going to be heard by the jury, and also will not be on a matter of record of the court. The court reporter is not going to be transcribing it. And you can see this most likely are two attorneys. One of the attorneys is showing the judge a document, and of course the other attorney has had an opportunity to review that document before it is being presented to the judge. First question is, what is a pleading? A pleading is a formal document in which the parties allege their claims and defenses. It is something that is filed with the court. The first pleading that is filed is usually called either a petition or a complaint, depending upon whether it is filed in state court or federal court. If it's filed in Texas state court, it's usually called a petition. If it's filed in federal court, it's usually called a complaint. That is what starts the lawsuit. Until this document is filed, the court has no idea there's even a dispute, and the clerk has no idea that they need to set up a file number for this particular matter. After the first pleading, the complaint or petition is filed, then the defendant has to file an answer. It's called, oftentimes called an answer. And this is a document in which the defendant responds to the allegations found in the first pleading, the complaint or the petition. The style of the response that the defendant files varies depending upon whether you're in state and federal court. Let's look at the things that pleading documents usually have. We have a list of, actually this is a list of the type of pleading documents. We said before that the complaint is what it is called if it's filed in federal court. The petition is what it's called when it's filed in Texas state court. These are the two documents, depending upon the court that you're filing in which the plaintiff tells the court, this is what happened and this is why I ought to recover, whatever it is I'm seeking to recover. The answer is the most common response that the defendant is going to make to either the complaint or the petition. In the answer, in a separate document, the defendant may also make a counterclaim or a cross-claim. This is like his or her own claim being advanced. If it's a counterclaim against the plaintiff, it's a cross-claim against a co-defendant. It many times is included in the answer, but doesn't have to be. There's also a possibility of a third-party claim. This is when the defendant says, oftentimes this is in the answer, that's in a separate document, where the defendant says, whatever he's going to say in his answer, and he says, oh, by the way, I want to sue, or I want to bring in somebody who isn't even a member or a party to this lawsuit yet. I'm not referencing the plaintiff or one of my co-defendants. I'm representing a third party who ought to be brought into this matter, somebody who isn't currently a party, and that would be a way to bring that person in. Let's look at the things that all pleadings need, whichever category these are. So you see here we have a list of 5 pleadings. This is certainly the most common of the first 3, but the bottom 2 are also certainly not rare. All pleadings, no matter which one of those 5 it is, are going to have these aspects. The first is the caption. This is the part of the document that tells the clerk who is suing who and in what court is being sued and what the case number is and what the court number is. It basically is a system to allow everybody to show up in the right courtroom and to make sure the papers are filed in the right place. Let me show you in our document, our assignment. This, everything above the word original petition, is the caption. So you can see the case number, in this case it's called a cause number, is right up here. And you can see on the right side where the section signs are, you know what kind of court it is. It's a district court. It's not a county court. It's not a JP court. Then we have the number of the court. This is the 192nd Judicial District. And we see the county that it's in, Dallas County. Obviously, if it were in Collin County, it would say Collin County. On the left side of the section symbols, we see who is suing. We see that there are two plaintiffs in this case. We have Larry James, and we have, actually Madeline West is not actually suing. Larry James is suing on behalf of Madeline West. Just a little trivia here. The term next friend is used in Texas to refer to the person who is suing on behalf of somebody who is not capable of suing. A minor or an incapacitated person lacks the ability to sue on his or her own behalf. And so Madeline West, actually, there are two ways that her dispute can be resolved. One would be for her to wait until she's 18. Then once she has her 18th birthday, she becomes eligible to sue. But another path, let's say she were, in this case, she's not much younger than 18, but let's say she were only 5, let's say it's her car accident case. Well, understandably, the family might not want to wait 13 years to get Madeline West whatever remedies that she feels that she's entitled to. And so under those circumstances, the next friend might be appointed to represent Madeline West in this litigation. Now, Mr. James is not going to benefit personally by this lawsuit. He is suing for Madeline West. So she is the real party in interest. You see that they're designated. They are the plaintiffs. Then we have a lowercase v period, which of course stands for versus. And then we see the name of the entity that is being sued. CEC Entertainment, Inc. This is the legal name of the entity. Then we say it says DBA, that stands for Doing Business as Chuck E. Cheese's. This is the assumed name or the fictitious name of this entity. So even though when we go to Chuck E. Cheese, we think of it as Chuck E. Cheese's, apparently the legal name of the entity is CEC Entertainment Incorporated. And it is listed as the defendants. Really, it should have just been one S there because there's only one defendant. So this is the caption of this particular case. If it were filed in federal court, this caption would look a little bit different. The court information would be up here. So it would say, you know, in the U.S. District Court, and it would give the location. Then over here, you would have the cause number. Of course, you wouldn't have any county information. But you don't need to worry about this. This is a Texas case that we're dealing with. The important thing about captions is find a caption for the particular court in which your case is going to be filed in or has been filed in, and you'll know how to set it up. A case filed in California is going to have a different caption, not radically different, but a slightly different caption than a case that's filed in Texas or in Wyoming or some other state. Let me pause here and point you to this little section symbol. Some courts or some jurisdictions, it's very common to have a column in the middle of the page with these section signals. And I'm going to show you how to do those. I'm going to open up a new document, new, blank, and I'm going to show you how to do that. Everyone's computer is set up a little differently. The way that it's set up on my computer is I'm going to click on the term Insert. And I'm going to go over here and go down to the word symbol and click on that. Now, if actually this is a new computer, so I haven't actually made the section signal before. If I had it would be one of these that are populated right here, and so I wouldn't have to do the next step. But the first time you use a symbol, or if it's been a while since you used a symbol, you're going to have to scroll through and find the symbol. Then once you find it once, unless you happen to use lots of symbols, it's going to be available for you. So I'm just going to scroll through and find it. And here it is. I'm going to click on this right here. And you can see there's actually a shortcut. I could click Alt and then 0167. I don't find that very easy to remember, so I don't actually use the shortcut key. I can actually make my own shortcut key if I want to, but this is the default shortcut key. So if you find it easier to do this combination, you can certainly do that, or you can go through this step. So I'm going to push Insert, and I'm going to close. And there is my section symbol. And then, of course, I'm going to want another section signal, and I'm going to do the same thing. Actually, I could just copy this if I wanted to, so I could copy it. Okay, now I'm going to paste it. Not sure about that. Okay, here we go. Oops, wrong one. Listen, I caught that. Okay, here we go. Let me oops. Copy. Enter. And paste. Oops. Caught some more stuff in there. But oops. Oops. Anyway, you get the gist of it. I'm just going to make another one for some reason. I'm not good on doing this with a laptop, but I could see now. It's my first spot here because I just used it, and I can enter again, and then do it again. Symbol, do that, and keep on going. So that's how you make that symbol. Some courts don't use this section symbol. They instead will use a close paren, and then we'll do this. This is easy. It's just a paren. Typically in Texas, you'll find that the section signal used more commonly. So that's a useful one to know how to make. So let's go back to here. So we've talked about how to make your caption. The next step is coming up with the name or the title for your document. And then, of course, you have to talk about the parties. Well, the parties' names are going to be in the pleadings, or obviously also usually mentioned in the body of your pleading. The body is the main section of your pleading. It's where you talk about the substance of it. There needs to be a statement of jurisdiction in the petition and the complaint, if you're filing that. In the answer, you're really going to talk about jurisdiction unless you object or you find that there's some basis or some statement about jurisdiction. Then you're going to request relief. Now, usually in an answer, you, unless you are filing a counterclaim or a cross-claim or a third-party claim, you're not requesting relief except for the lawsuit to be dismissed. And then you'll have a signature block. This is an opportunity to enter the information about your law firm and also to provide a place for the attorney to sign the document. Let's go to the picture here. So what does the caption must contain? Well, of course, the parties' names and titles. When we say titles here, oops, kind of got big there all of a sudden. Oops. Okay, here we go. We're talking about titles. We're talking about the fact that they're a plaintiff or defendant, then the court in which it's being filed in, and the case number, the cause number. And the clerk will assign this when the initial pleading, the complaint, the petition is filed. So every subsequent document will use that same number. And here is an example. I'll make this a little bit bigger. Of an example of a pleading. Again, this is a similar situation. Two people are the plaintiffs in this case, and two people are the defendants in this case. You can see the cause numbers going up here, which is typical in Texas State Court. You can see when you're filing the petition, you don't know which district court it's going to be put into. It could be several, because Travis County is a large county. There's going to be lots of different courthouses that could be filed in. Excuse me, not courthouses, courtrooms that can be filed in. And the clerk will add this number, and the clerk will also add this number. So for the petition and the complaint, if it's in federal court, these will be left blank. But when you are served with those papers as a defendant, you'll have this information, so you'll type that information in when you're filing your answer. The title. The title of the pleading must include the party who is filing the pleading and the nature of the pleading of the request sought. So you can say here, plaintiff's first amended petition. This, of course, assumes that all the plaintiffs are united. That if there's 7 plaintiffs, they're all together agreeing to file this first amended petition. If only one of the plaintiffs is doing it, then you'd have to distinguish yourself from the others, and you'd say, Plaintiff Bob Smith's first amended petition. If you file that, then let's say there's Sally Green as another plaintiff. Well, she hasn't amended her petition under those circumstances. And you see that in the second example, defendant, Red Bull's answer and affirmative defenses. And maybe there's only one defendant in the case, Red Bull, and the author of this has just chosen to point out that the defendant is Red Bull. On the other hand, it could be that there are several defendants, and the attorney is only representing Red Bull with respect to this answer and affirmative defenses. Then we also need a signature block. On the signature block, you need to give the name of the attorney, And the attorney, of course, has to be admitted to practice in front of that court. We're talking about Texas state court, so this attorney has to be admitted to practice in Texas state courts. And then also the name of the law firm. Then you need to provide the attorneys, and of course, you'd only provide the attorneys who are actually involved in this case. Many times, only one attorney will sign a document, but there may be several names of different attorneys who are listed, and their bar numbers may be provided. You use state bar numbers whether you're filing in state or federal court. Then you need to provide the law firm address, the telephone number, and fax number for the law firm. And you'll need to list the name of the party who this law firm is representing. And this is an example. So it says respectfully submitted. That's standard closing language for a pleading in court. You see the name of the law firm, Ebola and Associates PC, and then there's a signature of the person who's filing it, Sunny N. Share. And then you can see that the state bar number is there. Then there's somebody else who filed it, P. Slovan Understanding. And of course, this is the person who actually signed it, and his bar number is below that. Then we have the address of the law firm, Ebola and Associates, both the street, the city, and the name, the telephone number, and here it's called a telecopier number. A little bit of an old-fashioned way of phrasing it. You certainly could say facsimile number. And here it describes who the attorneys, the Ebola and Associates law firm is representing. They're representing Nationwide Home Loans Incorporated. So that is a good example of a pleading a signature block. So that gives you an overview about how pleadings work. Let's go to our folder here, Learning Module, down here for Pleadings. And we're going to look at the answer format. Let me go back here. There's a little bit of a discussion about this beforehand. I think it's useful. Please review the information provided about the general denial in Texas. If you have not yet taken Texas civil litigation, this is something that you may not be familiar with. You may recall in federal civil litigation, filing an answer to a complaint in federal court is a pretty involved process. You have to admit or deny every single allegation in the complaint filed by the plaintiff. That's not how answers are in Texas state courts. In Texas state courts, you are entitled to file what's called a general denial. And most of the time, that is what is filed. So what is a general denial? In a general denial, you do not need to address any specific allegations contained in the petition. When preparing a petition, pay special note to the caption, certificate of service, and signature block. Pleadings are documents that will be filed in court, and you will serve, meaning provide a copy of each pleading filed to the other parties in the lawsuit. As you complete this assignment, please contemplate how you will effect service, how you will deliver your documents to the other parties. You are going to need a properly addressed cover letter to accompany the delivery of your documents. So let's look at this example. Okay, so you can see that the first thing that you're going to notice, let's actually look at the assignment before we go too far. This is the assignment. This is the original petition that you're going to be responding to. And so here, you're going to see the cause number and the court, and you see the name of the document you're filing, and then there's all of this information. But if you were in federal court for this one, you'd have to go through each one of these statements and admit or deny it, but you don't have to because you are in state court. So all of this, you're just going to do a general denial, general denial. Then when you get down here, you're going to have your own signature block. This signature block looks like it's been prepared very appropriately. It has respectfully submitted. It has the name of the law firm, Baker & Schultz, LLP. It has the name of the attorney who will assign the document, her bar number. It gives the address of the law firm, Baker & Schultz. It gives the telephone and telecopier number, and it indicates that Baker & Schultz represent the plaintiffs, all of the plaintiffs. In this case, there's only one plaintiff, so I think they probably could have said plaintiff. So Mr. James, who is the next friend of Madeline West. And so you are going to want to file a responsive pleading. But you may think, well, what is that going to be? Well, we've already covered what that's going to be. It's going to be the original answer, right? The general denial. So you'll have the case number, you'll have the plaintiffs, you'll have the defendants. And by the way here, it's not considered a good form to do a capital V or to include the S. It'll be a lowercase v and an S. And of course you won't be using the lines, you will have typed it up. This is for small claims court matters when you have people that are being a little bit more informal, but obviously your client's paying a lot of money and so he is going to want documents that look professional, and the court's not going to be too happy with a law firm that submits handwritten documents. So you will type the name of the plaintiff, put a comma, and then put plaintiff versus lowercase v period, and then the names of the defendants, comma, and defendant. You will not need to underline that. You'll put the case number. Again, you won't need anything underlined because you're going to type it out. You use the little section symbols. It won't be in a small claims court. You'll, of course, use the same court information that we had in the original petition, and you'll include the county as well, and you will say defendant's original answer. That would be a good name for it, and you'll have this title, to the honorable judge of this court, and this is very standard language for that general denial. Comes now the defendants, and of course if you have more than one defendant, you just use an S. If you only have one defendant, then you'll omit the apostrophe, the parens, S parens. In the above style case, and of course when we use the term above style case, what we're talking about is in this case, in this cause number, in this case with this caption. So comes now the defendants in the above style case who enters a general denial pursuant to Texas Rule of Civil Procedure 92. It's probably a good idea for you to look it up before you apply for that, or you assert that basis, but that is the rule that allows defendants in the state of Texas to file a general denial. And then this is what a general denial is: denying the allegations set forth in the plaintiff's petition and denying plaintiff's claim. And maybe pausing here and thinking to yourself, if you've taken federal civil litigation, well, that doesn't sound right. I mean, we talked about in federal civil litigation, there's surely going to be some statements here that are things that everyone agrees to. For example, even if Chuck E. Cheese really doesn't like Larry James and Madeline West, they're probably going to agree that Madeline West is a minor. And even if they don't agree with that, they're probably going to agree that Madeline West and Larry James reside in Dallas County. They're not going to disagree with every single statement. They're probably not going to disagree with the fact that Chuck E. Cheese is a Kansas corporation. And they're probably not going to disagree with who its registered agent is. That's probably all correct. So how can they dispute that when in fact it's true? Well, a general denial gives you that right. You're not really saying, I dispute it in the sense that I'm saying it's untrue. What you're saying is instead, I require, as I am entitled to force the plaintiffs to prove every single allegation in their petition. So I'm putting them to their proof. They're going to have to prove these statements. I'm not going to concede anything. I'm not saying that it's true or not at this point. I'm just saying I am denying it, and you are entitled to deny it. It's a little bit like when you are a criminal defendant. And even though in your heart of hearts you know you're guilty of the crime, you can still plead not guilty. That isn't perjury. Now, to get up on the witness stand and say I didn't do it when in fact you did, that would be perjury. But a plea is not an assertion of a fact. It is making a plea to the court, not making a factual assertion. So you can do a general denial even if there are aspects of that original petition that you believe are factually accurate. So the next line is where we ask for our remedies. Wherefore, premises considered, defendant prays that the plaintiff take nothing in this case and the defendant go hence without day and cost of said suit be taxed against plaintiff. Now this is a very strange sentence, but this is kind of many times what is called in the law boilerplate. Many times this paragraph is called wherefore premises considered. Usually there's an S after the word premises. But I suppose the reason why they didn't include it was there's just one really premise being stated, which is the general denial. So probably the lack of the S is more grammatically correct. Basically what it's saying is the defendant is saying, hey, Your Honor, make the plaintiffs go home and leave us alone. Make this case go away. They should take nothing from this case, and the defendant should not have any delay in getting this resolved, and actually the defendant ought to get some money because it's not nice for the plaintiff to suit it when it doesn't really have a legal basis. So that's what they're saying. Excuse me. And then that's all we have to do for a general denial. And many times in a general denial there will be, in addition to the general denial, affirmative defenses. For this one, you are not required to provide any affirmative defenses. So you have the text right here of what your journal denial is going to be. And you will have your respectfully submitted document. Again, you're not going to say mailing address. You're actually going to provide in type form the mailing address. You're also, since this is designed for a pro se litigant, it provides, when I say pro se, I'm talking about somebody who is not hired an attorney to represent him or her. He or she is a lay person who is filing this on his or her own behalf. So there's no attorney to be listed. So you would change this up and you would provide the name of the law firm, the name of the attorney who is representing the defendant, and then of course all that other information that we saw. Right here. The equivalent information from here. So this is a good setup for this. You'll also want to set up a nice footer along this line. So why don't you model your footer along the same lines that we find in this document. Okay, so let's go back to the assignment at the beginning and look at what the instructions are so we make sure that we have an understanding about the different tasks we need to perform. You are the sole paralegal in a litigation law firm, Montagna, Alason, and Marino, PC. Your law firm represents CEC Enterprises. Your assignment is to draft the appropriate responsive pleading to this lawsuit. Therefore, you are to, number one, draft the appropriate responsive pleading that answers or otherwise responds to the allegations set forth in the petition. So we've already decided what that's going to be, a general denial, and we have an example of a general denial that obviously you're going to have to change to reflect this particular situation, but it gives you some language that you can use. It's very common in the law to cut a little bit from one document and to cut a little from another document and merge something together. And then, so that's one task that you need to perform. The next task you need to perform is you need to prepare an appropriate and properly addressed. This should not be an S here. This should be a D there. Prepare an appropriate and properly addressed cover letter for the clerk of the court where the document will be filed. You should use the appropriate letterhead for this letter, so you'll need to find the Montagna, Alason, and Marino PC law letterhead. You'll find that in your sample docs file. And know the rules about dating correspondence that have been described in previous assignments. So again, if you submit it during a Monday through Friday day before 4 p.m. on Friday, you should use the current date. Of course, if you submit the document, say at 8 p.m. On Monday, well, you'd use Tuesday date because it's not going to actually be mailed or put into the mail system on Monday at 8 p.m. So you'll have to think about that. If you actually turn in your assignment on Saturday, you'd want me to date it for that Monday, assuming that Monday is not a court holiday. I am not assuming that we are electronically filing these documents. I'm assuming that we're filing the good old-fashioned way. I realize that our court system has been changed, but we're not going to worry about that aspect of it. We're going to pretend we live in a paper world where these documents are filed with paper. So you're going to have a cover letter to the clerk of the court. You'll need to look at the court's address. You'll want to make sure that you have appropriate subject line, an appropriate ray line that describes what you're filing. You're probably going to want to include the parties' names and the cause number for that particular court. You'll want to say, dear sir, madam, or if you happen to know the gender of the clerk, then you would say, dear sir, or you'd say, dear madam, depending upon the circumstances. And then you would have just a very short 2-paragraph letter that, in fact, states what you're filing. And I'm submitting this, please file it. And then you would have a very truly yours or sincerely yours signature place that would include an opportunity for the attorney to sign this. You are not given the name of the attorney in this particular assignment, so you can just pick one of the names off the letterhead that you think might be appropriate. And then you will want to CC the plaintiffs in this case, because of course you are required, let me go back to the pleadings letter, you are required to get a copy of this to the plaintiffs, and we don't actually have a certificate of service. Maybe we have it. go back here. Oh, here we go. Here's our certificate of service. So this is what a certificate of service would look like. Again, you're not going to prepare it with these blanks. Usually you will leave a blank for the day of the month, but you will type in the actual month. So you would say the blank day of whatever the month is, comma, then whatever the year is at the following address. You can, in fact, type in the day, but more commonly people leave it blank because sometimes there's an issue about, well, which day are we actually going to send this out? And so that's appropriate to be handwritten. And then, of course, you would actually type out the address here. You would not say plaintiff's address. You would say you're sending it to whomever it is. Of course, you're not going to send it directly to the plaintiff because plaintiff is represented in this case. It would be an ethical violation for a law firm of one party to send directly to another party communication. So you'd send it to the plaintiff's counsel. And then you'd have a signature. You'd prepare this again for the attorney who's going to sign the general denial. The attorney would also sign the certificate of service as well as sign, of course, where it says respectfully submitted. And so that should get you set up nicely. If you change the name of your document, you don't have it be defendant's original answer. If you change it to something else, and you would obviously change the name up here in your title line, and you would also change it down here. So let's go back to the assignment and make sure we haven't missed anything. Looks like you're in good shape. If you have any questions about the correct format for a letter, this is a business letter just like all the other business letters, but for example, the one that you sent to the client. So the same rules, we'd still be using modified block format following the same procedures that we did. So be sure that you're following them, that you're putting your ray line where it should be, you're putting your date where it should be, you're including things like the method of delivery and things along those lines. Good luck with the assignment. Again, if you have questions, feel free to come to my office hours. If you have a question that you think can be simply answered via an email, you're welcome to send it to me. And if I think it's a question of general interest, I will send a blast email. Otherwise, I will respond directly with you. Good luck with the assignment. Good luck with the unit. Thanks for your attention. And I am going to end the desktop sharing and say goodnight.